Okay, I'm just going to follow up on some of the things that Judge Garza talked about with y'all on Monday. And one of the most important things to remember is that the judiciary plays a vital role both in law enforcement and public policy in the state of Texas. There are some very real concerns, though, about whether or not the system is effective at being fair while protecting the residents of Texas. There are definitely challenges to the legal system in Texas, but the legal system is still better than it is in other countries where judges make all the decisions and juries are non-existent. The absence of juries increases the possibility of bribery and corruption. In many respects, there's no part of state government that affects as many lives as the court system. The legislature makes laws, but the judicial system processes more than 10 million cases a year, even though the vast majority of them involve traffic offenses in JP and municipal courts. But this also means the judiciary crowns winners and losers through a political process. The law. What is the law? The law is an organized system of rules of conduct that is backed by the organizing force of the community. What does that mean? Well, it means that basically people come together and they agree on a common system for how they want to handle disputes, and the state has the ability to enforce those laws. So rather than people taking the law into their own hands, imagine, kind of the vigilantism or the Hatfields and McCoys where, you go an eye for an eye. The law is designed to provide that because we have rules of conduct. You shouldn't kill people. You need to honor contracts. There are limits on how fast you can go. And if you violate any of those things, the state, not an individual, but the state, whether it's the state of Texas or the United States government, has the ability to enforce those laws to make sure that you're doing what you're supposed to do. One of the things that's critical to the legal system in the United States is this idea of common law. The idea of common law dates back to the Middle Ages, and judges are the primary focus. In the Middle Ages, we didn't have a legal system like we're used to today. Instead, judges travel to resolve disputes in different communities, and when presented with the cases, the judge made decisions on the basis of their knowledge of the law, the judge's own reasoning, and how he had decided similar cases in the past. Thus, the common law is characterized by the accumulation of reasoning, and this is vital, right? And so when I say accumulation of reasoning, we're talking about judges deciding lots of cases based on their own interpretations. And so this is vital for three reasons. One, it provides consistency to rulings, right? It's one judge. So if you're going all around a particular area and you're the one making these rulings, you're going to be consistent. Number two, it allows the judges to adapt knowledge of other cases to local circumstances. So judges were not immune to what was going on in local communities, but they would take that into account. And, we see that in the United States. In our federal system, the law does operate differently in some states. And then number three, judges have flexibility interpreting the law over time. Norms change, right? Our expectations change. And so judges would have the flexibility to be able to do that. State laws come from different sources. And Judge Garza referenced this. We talked about the difference between constitutional courts and statutory courts. So the state constitution is a source of laws and establishes certain rules. For example, the state constitution says how long a member of the state house serves, 2 years, right? That's a law that's established in the state constitution. Similarly, when the state legislature passes a bill or a statute, for example, in 2015, there was Senate Bill 11, which established the policy of campus carry at public colleges and universities in the state of Texas, which meant that if you had a concealed handgun license, you could bring your gun onto campus starting last fall. Okay, so that's an example of statutory law. City ordinances, that's the third source of laws in the state of Texas, right? City ordinances where the city can say, well, look, your bushes can only be this high in front of your house, or what's become the real flashpoint in Texas. What laws can states make or what laws can municipal governments, local governments make with regard to who can use what bathroom, right? This is the heart of the dispute in Senate Bill 6, the bathroom bill. So you have these three different sources of three different sources for state laws, right? The state constitution, statutes that the legislature passes, and municipal ordinances. Now, one thing to keep in mind, though, is that any law that the state of Texas passes must comply with the United States Constitution. We have a federal system, and every state, including Texas, much to our disappointment at times, must conform to the rules that are established in the United States Constitution, but that does not mean that challenges are impossible. So remember, if you go back to Political Science 2305, the U.S. Constitution establishes the basic framework, but the specific application of various clauses are open to interpretation. For example, the right to privacy and abortion, or the conduct of elections, right? A lot of you wrote about that in the Unit 3 blog, right? That the state is responsible for running elections, but they have to make sure they don't clearly discriminate against voters. Okay. In addition, besides the Constitution, the states do have to follow the laws that Congress passes or regulations that are passed by various bureaucracies in the federal government. It is important to understand, though, there is room to challenge these decisions, right? We've talked about this in class. Many of you expressed your surprise at how many lawsuits the state of Texas has filed against the United States government. And so in Texas, our elected officials, first Governor Abbott, as Attorney General, and now Mr. Paxton, as the current Attorney General, has led efforts in the United States to limit the effect of the Affordable Care Act, to challenge regulation of carbon dioxide emissions, challenging the rules with regard to immigration. So the state of Texas is free to challenge laws, okay? And it's important to understand as well that the judiciary can check the power of both the legislature and the governor. So, for example, in Texas, the Texas Supreme Court, which we'll come back to in a little bit, can rule whether acts of the legislature are constitutional. So, for example, school finance is one of those classic examples, and we'll talk more about school finance next week when we talk about public policy. But currently, the system of school finance takes money from wealthy districts and transfers it to poorer districts, and some school districts in the state have challenged that as whether or not it's constitutional in terms of providing an equitable education for all children in the state of Texas. And last summer, the Texas Supreme Court, in its infinite wisdom, that sounds actually really bad, but in their decision, they referred to the existing system as Byzantine or unnecessarily complicated. And while they said it was unnecessarily complicated, it was deeply flawed, it was broken, it was not unconstitutional. And so this has allowed the legislature to avoid tackling this problem during the legislative session. The judiciary can also check the governor by ruling whether or not some of his executive decisions are constitutional or not. So the judiciary serves as an additional check upon the other elected branches of our state government. When we look at the court system in the state of Texas, it is important to understand that the courts handle different types of cases, and Judge Garza touched on this very briefly, and I want to come back to this. And I want you also to understand that almost all, probably more than 95% of all the legal cases in the United States are actually decided in state and local courts and not the federal courts. So what is jurisdiction? Jurisdiction is simply a matter of who has the right to hear a particular case, but there are two different types of jurisdiction. Original jurisdiction means that a particular court has the ability to hear a case first. What does this mean? Well, one of the core components of original jurisdiction is establishing the facts of a case. And what does this mean in simple English? A trial. A trial that you've seen on TV where the lawyers for each side make arguments, they call witnesses for testimony and cross-examination, and they introduce evidence all towards establishing whether or not the defendant is guilty or innocent, or in the case of a civil trial, whether or not someone is responsible for doing something. Appellate jurisdiction is a little bit different because appellate jurisdiction means that a court does not hear the case first, but rather it serves as a check in the system to ensure that the law was applied correctly. And we'll come back to that in a minute. In addition to the distinction with the jurisdictional issues, there are also to talk about different types of cases. For example, in a criminal case, the state of Texas, via the counties, all 254 of them, charge an individual with violating a statute that has defined some act as illegal, right? You can't kill someone, you can't run someone over with your car, you can't take things out of someone's house that don't belong to you, and so forth. And in criminal cases, the state of Texas is the plaintiff, which means they bring the case, and the individual accused of a crime is the defendant. The burden of proof, as Judge Garza talked about, is beyond a reasonable doubt, which means the instructions to the jury must say that if you have any doubt in the back of your mind, you have to vote that the person is not guilty. You have to be convinced beyond a reasonable doubt, although that is going to differ from individual to individual. And this is important because in a criminal case, a conviction can lead to serving time in jail. Civil cases are different. Civil cases deal with the obligations that exist between people. And the state of Texas can be involved in some of these cases, but the primary decision is between two individuals or between an individual and a corporation. And these cases often involve negligence or people who are not fulfilling a contract. So let's say you agree to have some work done at your house, your car, or something else, and someone doesn't do it, you can file a claim. And when you have negligence, right, someone trips, someone falls, these types of cases are called torts. And in civil cases, the burden of proof is lower. You just have to prove that the other person is more responsible than you. And in a civil case, jail time is not a possibility. The nature of the legal system in the United States means that anyone who's been accused of a crime has the right to appeal the decision of the court of original jurisdiction. It's part of a system of checks and balances that prevents any single court from having absolute authority. It also draws on the idea that truth or the correct answer can be discovered with numerous sets of eyes. And the purpose of the appeals process is ensuring that the law is correctly followed, and the appellate courts will rely heavily on the record that's established in the courts of original jurisdiction. Okay, 2 points here. Should an appellate court find in favor of someone convicted of a crime, it does not mean the person is innocent. It simply means that the law was not applied correctly, and then the case is sent back for a new trial. Double jeopardy is not a problem because the person appealing the case is effectively waiving that right by filing an appeal. The trade-off in the system, though, this is the point number 2, is that it results in greater costs and increases the potential for delay. Article 5 of our state constitution talks about or discusses the appeal system in the state, and history really matters because the structure of our judicial branch is no exception, right? The state constitutions of 1824 and 1827 had local and state courts, but the reality is that since appeals courts were located hundreds of miles from Texas, it often meant that the settlers had little recourse for decisions that were rendered in local courts. During Reconstruction, resentment of centralized authority meant that people wanted greater accountability. And so the end result that we get is our state constitution divides the judiciary into many courts, and it provides both for local access as well as for allowing for people to appeal those decisions.